Thank you very much, Honorable Professor Toad, Dean of the Faculty, distinguished professors, judges, colleagues, ladies and gentlemen. Thank you very much for the invitation of this conference, and thank you for asking me to present the first speech today. And Prof.dr. to the university is not too far from me because I was graduated and I got the first degree and the second degree at the Prof.dr. University. Dear colleagues, when we talk about law, jurisdiction, administration of justice, the court system here in Hungary, if somebody asks the name of the most important judicial institutions in Hungary, of course, I would like you to say it is the Curia, but you probably mention firstly the Constitutional Court. The Constitutional Court, the Curia, the Supreme Court, and so on. And then we will draft up the entire organization of the courts in Hungary. Obviously, we will talk about civil, criminal, or administrative justice, including electoral adjudication, but it's going to be focused again next year here in Hungary. A more difficult question is if we ask, what is the fundamental feature of justice? You could say many things about this, depending on which professional field is closest to your heart. But what does justice actually do? It transforms, as it was mentioned, and as it's presented in the title, it transforms social phenomena into legal disputes. I would say that social disputes that cannot be solved overnight will sooner or later turn into legal disputes. These social disputes, social conflicts erupt in society, which, in the broadest sense, means organized society, micro-society, family, and business. And it is the task of the justice system to mitigate these disputes, to tame social conflicts into legal structured disputes. And this is not self-evident. If I may say something very solemn, we can say that it fits into the, and it fits into the opening speech, of course, to be a bit solemn. Let me mention that this is one of our exceptional European cultural heritage since the Roman Empire, or rather since the Old Testament way of thinking incorporated into modern Roman law. That is a characteristic of the Old Testament way of thinking, that it presents norms and standards to the society, and if these standards are violated, we will not leave it up to the community to react in some informal way, but essentially we will decide based on previously decided formal legal, we can say, formal legal norms. If something is intolerable to the community, we will solve them based on these norms, because this is, and this is why I said that it's a cultural feature, because this is the main difference between moral judgment and application of law. The difference between them is not that they are more or less or completely detached, but the morality and moral rules are fundamentally also positive rules, just like legal rules. The only difference is that the moral adjudication, the moral evaluation, is a one-step process. We state that something is beautiful or not, good or not, allowed or banned, honest or dishonest, and then we leave it up to the community to decide what happens next. If we accuse someone of harming the community, if we use only moral rules or moral norms, we say that this is not correct, and it's up to the community to react. It's up to the community to do something with that. But if we apply legal standards instead of simple moral standards, then the story does not end with us saying that there has been a breach of contract, and it's not good. The contract has been properly performed, and this is good. Somebody is guilty, it's not good. Somebody is not guilty, it's good. Or that something is lawful or unlawful, because if we don't stop at these moral points, then if this conflict is transformed into a legal dispute, then we will continue to something else. In this situation, during the legal disputes, the story continues with the question, what comes next? And here we have the key word. In legal disputes, there is a mandatory application of legal consequence. And this is the main difference between morality and law. That application of the consequence is mandatory. We will not choose the answer, the reaction to a breach of a norm, as it happens in the field of morality. Here we have a previously decided consequence or set of consequences, and the application of these consequences is mandatory, is a must. This is the question that universities, especially legal scholars, argue about so much. Could we say that the distinctive feature, the differentia specifica of law, is enforceability? But it's not true. Not the enforceability is the main thing, because we have a lot of legal norms which are practically not enforceable. For instance, the capital of Hungary is Budapest. It's a legal norm. Is it enforceable? So if I say that no, Székesfehérvár is the capital, the ancient capital of Hungary, what happens? Nobody will come to me and to take me away from this hole because I told something illegal. It is illegal to say, but it cannot be enforceable. Why can we say that this short norm that the capital of Hungary is Budapest is a legal norm? Because it has mandatory legal consequence. If Budapest is the capital of Hungary, then the administration of the local government of Budapest is different than the administration of local governments of other communities in Hungary. This is the legal consequence, and this is mandatory, that only Budapest has the right to elect a chief mayor, not a simple mayor, that we have the districts and district local governments, and so on. So this is why we can say that not the enforceability is the main character of law, but the compulsory, the mandatory application of the previously declared legal consequences. And this is why we can say that moral norms are not enforceable at all. Can we say this? No, they are enforceable. Try to go to a simple community, for instance, a group of friends of a football team. If you say that you like better the other team, in that community is, of course, a breach of moral norms. In Hungary, if I go to Fradi, to Ferencváros, and I say that Újpest is better, then it's a breach of a moral norm, and there will be a legal consequence. I'm afraid very hard. I'm not sure that I could have survived such a situation. But the outcome, the solution of this breach of morality is not previously declared. So it's not declared that I will got the first hit from left or from right, and the second from the other side. So moral and legal consequences can be enforced in the same way, but not the enforcement is the most important. In conclusion, let me just say that we cannot claim that this situation, that we transform the social conflicts into such legal disputes, is not natural. Just think about how many types of disputes there can be, starting from a situation where I sell my cow and it dies when the buyer goes home, hands home it, or to the question, what is the outcome of election? If I mention the electoral adjudication, the question, or whether or not the campaign is good or is fulfilled in a good manner or not, and so on. This is the case regardless whether it is about someone arguing with their neighbor until they accidentally hit their head, or about someone building a fence that falls on the field of the other neighbor. These are the general social situations in which decisions, solution of conflicts must be made. Now, in societies other than those of the medieval Europe and those which have adopted the European cultural heritage, this is not so apparent today. But 50 or 100 years ago, it was very clear. So what happens in situations where there is no conflict resolution based on law? Something will happen. But what will actually happen in places where we build this solution of conflicts on the system of law? Three parties will come: the plaintiff, the defendant, their legal representatives, and sooner or later a judge also will join them. Or three judges in appeal proceedings, and in Hungary 5 in cassation proceedings. A team of members of which form are formed in a single academic school with a single professional training will discuss the issue. Lawyers, practically. It is a legal dispute, and these persons, this group of professionals will discuss it as such. And it is not the dispute itself that is interesting for us now, today, but the fact that the society accepts in advance whatever comes out of it. So I have a problem with someone, I disagree with someone. We each hire an advocate, a lawyer. We try to explain our problem to these two lawyers. They will say that we should reach a settlement, but reject this, explaining that we cannot accept the situation. Well, okay, there is no problem, let us go to a court. At the court, there are 1, 3, or 5, or even more experts. In Hungary, in uniformity questions, 21 judges. And at the moment when the documents, when our claim arrives to the court, both parties will accept beforehand that whatever these professionals' team decides will be ultimately binding. This is the very special feature of the European culture based on Roman law that we should look after, and that brings us, for example, to the electoral court. Next year, this will be in focus, as I mentioned. We have arrived at a point where we can see that there is a certain segment of social debates, or a certain segment of our social phenomena that is called politics. And this is what elections are all about. In short, it concerns the question of who exercises political power in such a way that all those things which take place there will become final after a while, after the campaign and so on. What we do later? We destroy the ballots in the same way as in the conclave during the papal elections in Rome. We do this not as quickly and not in very, very spectacular forms like in Rome, but the same thing happens. Let me ask between parentheses again, why do we this? Because we do not usually pay attention to this simple feature. We do this so that no one can dispute the outcome after a legal remedy process is concluded before courts, including the Constitutional Court. From then on, nobody should be able to say that what it was not correct, it is not like that or that way, or nobody can argue that the outcome of an election is different than the legally binding solution or the legally binding uh, declared in a legal binding form that this is the official outcome of the elections. Nobody should be able to say we should take a look or what happened once again and once again and once again. So these questions at a court or at several courts are decided in the long term. This is the political interpretation. But what does the court do? What does the law do? It creates a legal dispute out of the political conflict. Just as the law was invented in Rome to settle disputes arising from commercial transactions, firstly, and trade problems. In electoral adjudication, whatever we like it or not, a kind of political conflict is transformed into formal, structured legal dispute, and we have to decide on these legal questions and not the basic, the fundamental political question. Obviously, this is the matter that could be the subject of an entirely separate conference, and it was a subject of another conference just in the same room, because we have now reached the very interesting topics that are covered the newspapers and the posts of the internet. We say that, of course, that in our culture, courts are politically neutral. Natürlich, says the German. But what does politics decide on in a neutral way? Political issues. Of course, we have put on the legal knight's armor and reframe the political issue as a legal one, but we cannot escape from the political force field as judges because this transformation takes place. It is obviously true for the election committees in the election offices as well. So nevertheless, we decide on political issue as a legal dispute, and our decision naturally has political consequences. And this is the second pillar. Even if we transform the political debate, the political, okay, let I say just debate and not choose stronger words, the political debate into a structured legal dispute, and we decide the political problem converted into legal questions, but the outcome goes back to the political sphere, to the political arena. Why? Because our decisions, of course, has political consequences. If we declare the election void, has one political consequence. If we declare that everything is correct, has another political consequence. So this kind of going back, of changing always and always the nature of the disputes from political or social to legal, and the consequence goes back to the field where it comes from. What is, in this situation, our task as legalists, as professionals, of course, if we are judges, as judges, to try to distance ourselves from the fact that our decisions have these political consequences. We should not forget, however, even for a moment that we make a decision in the political force field, we should try to succeed moving away from the political sphere. But can we achieve these situations to depart us forever and finally from the political force field? And what will be the result if we succeed this? We are talking about lawsuits, and it is generally characteristic of public law litigations that there are no major settlements of administrative cases, and that settlements are not very, very common. Therefore, it will clearly result in the fact that there will be a losing party and a winning party. In civil law field, it's not necessary, but in public law, practically no friendly settlement can be achieved, and of course, not in hard political questions like electoral adjudication. And here comes my next point, and this is why I spoke so lengthy about the role of courts in European culture. It follows from this that this system only works if, with regard to the courts, society agrees to entrust the dispute to a professional team, that is, to a 1-3-5 members team, with making a decision and accepts the decision in advance as a binding one. However, one more thing must be added, namely that the process of trying to transform political disputes into legal ones was emerged from the 19th century and must be stopped at this point and must not be reversed. What did I say in my last sentence? From the 19th century, it was decided, it was a friendly settlement of the society, that if we give the political problem into the hand of justice, we accept the outcome not only as legally binding, but we will not reverse this situation and we will not include the judges and the courts in the political disputes. We leave the courts to decide on the questions and we will not put them how to be, as parties in the battle. In other words, we should not start again a political kind of discourse on those legal disputes which have been closed by a court. In short, we will not start political mudslinging at the courts. Why? We should not do this for several reasons. One of the reasons is that the court is defenseless against political attacks, and cannot do anything if faces accusation of sailing under this or that color. So the court is unable to do anything about it because all it can say is that it does not present the court does not represent a particular color. But if we really transform the legal disputes back into political debates, this will not result in reversal of our colors. Instead, the outcome will be that it favors one color or other color. You understand what I'm talking about. Courts cannot participate freely in public legal or public political debates in free social discourse based on the freedom of expression. And of course, nor can other judicial institutions. Like it or not, this is the way. I'm aware that there is currently a debate now in Europe about what judges or courts' freedom of expression is like. Obviously, there was an extremely strict limit until about 10 years ago, which was good because it was easy to comply with and it was silly. Judges could speak in the courtroom, but they could say nothing about public issues outside of the courtroom if it's possible. Obviously, this was very, very rigid. Obviously, it had to be somewhat relaxed. Obviously, in the era of postmodern deconstruction, we can come up with 3 questions for everything, 3 random questions about everything. And if we answer those 3 random questions, then we can deny the binding force of any legal or other social principle. So what does it mean? In which era we live now? I can say that we have a very, very strong legal principle. For instance, pacta sunt servanda. The contracts may be fulfilled. In any question, even if I told this, if I mention this principle, we can say 3 questions that, is it true when? Is it true then? Is it true in the situation when? And we can say that, yes, pacta sunt servanda, the contracts must be fulfilled, but not if. 1, 2, second. What is the outcome of these situations based on our main way of thinking? And I think this is one of the most important features of theory of law. If our thinking about the reality is based on deconstruction, then no legal principle is valid, because we can invalidate each of them. This is the point where the boundaries fall between the cracks. In any case, I will return to what I have just said, namely that judges and courts should be excluded from these public debates in the era of deconstruction. We have to take away ourselves from the completely free expression or political or social opinions as far as is possible, for the simple reason that this is the prerequisite of judges to be able to complete our first stage and to transform social conflicts into legal disputes. As soon as courts lose their credibility, nobody will believe them. I will conclude this part of my speech because it can be summed up very, very briefly. If we get to the point where people may say, it's my judge, it's your judge, it's a third party's judge, then this story is ended. It goes to an end. There are societies where this is quite common. Then we will actually be propelled from the center toward the plaintiff's view and the defendant's view. Obviously, there are jurisdictions where this is relevant, of course, for example, in the jury system, where someone can be voted out from the jury or can be challenged if any doubt arises over him. But that way may not work that courts are involved, the judges are involved in the debate without restriction, and it is self-evident in the Anglo-Saxon world which operates the stronger justice system, but not in the continental way. What this is all about is that we have made everything immensely complicated. As an example, I will mention the complexity of public law judgments by election cases adjudicated by the Supreme Court, the Curia of Hungary, as a first and last instance court. We have to evaluate great many details, and yes, even in the simplest cases, such as election judgments, we started to write long, complicated reasonings and evaluations. So how can we start to do something about very, very simple situations? And this will be at the end, and then I will mention a couple of specific points. We have the question at hand, why are our judgments, even in simple cases, so long? And the answer can be given through another question. Who adjudicates election cases in Hungary? The Curia. Very good. But why exactly the Curia? Because this is in law. From the other part, what is the main, the fundamental, the everyday role of the Curia in Hungary? According to fundamental law, the Curia is the court responsible for the uniform application of law in Hungary. So it does not primarily decide on specific legal disputes, but rather focuses on the general application of law by other courts and, of course, by the panels of the Curia. Again, here in Hungary, there is an ongoing debate, and we have been talking about it quite a lot recently. The Constitutional Court often says that it is not a fourth instance court. Criminal law judges know why I'm saying that the Curia cassation proceedings are not a third instance court proceedings either, because in criminal justice we have the third instance and we have the cassation. So this extraordinary remedy lends the Curia some type of special functions. This is, the Curia should deal with ensuring the uniform application of law if possible. Why has this been given such prominence? I do not have time to go through it all, but I will just highlight one or two main aspects. I already have the formula because we live in an era of postmodern deconstruction. Words do not have words. No word of our language or other language have a universally accepted meaning. Consequently, nor do the sentences. As a result, we have been saying useless for 150 years now that the law must be enforced, and that if the legislator said that the law would have a certain meaning, then the law would mean that. In Hungary, you cannot find two people who would agree that the simplest legal provisions means the same thing. Now, obviously, I'm not going to argue at length about this basic idea what happens in criminal law when there is an open legal situation and someone kills another person. Does it count as a murder if someone puts antifreeze in a Sprite bottle and the other guy drinks it? It was written in the 19th century, but they left it open, so to speak, on purpose. But in specific cases, what is a firearm, what are narcotics, or what is a building? Do we have to apply these townscape provisions included in the townscape buildings regulations even when we do not build anything? Very, very actual questions. Only an apartment house is converted into a hotel, or a hotel is converted into apartment house. So even in the case of the simplest social questions, we can see that the word written down, the meaning is disputed. Now that there are two parties with conflicting interests, this is the situation at the court. It is certain that today we are no longer primarily arguing about the facts in court. Instead, a legal dispute goes beyond the mere discussion on facts. What do legal regulations mean, and which one should be applied? The domestic or the European one, and so on. In these situations, it becomes more valuable in Hungary that the Curia of Hungary must state that it has looked as a case. There were several solutions, but this one should be followed. There can be several answers what a legal regulation means, but the Curia has the job and the power to say which interpretations should be followed. Is this a good thing? Well, it will simplify the question by saying that maybe it is good or not, but go ahead and come up with something better. Anyone may say that all legal disputes should remain open for until the end of time. So you can keep brainstorming or thinking up something else to try to have a next or a third or a fourth new decision. But just please recall how I started my entire story. The role of justice system is to transform social disputes into legal disputes and to close them as legal disputes. And this is important. So the goal is not to have a permanent legal disputes at the end of the times, because then we are redundant. We will go back and back and back, and the case will not be closed, and the social conflict from which arises the legal dispute will not be solved. So we can argue without us to until the end of time about these problems. You can do without us, and you can be a legal expert. This is why it is important, because these arguments, these disputes are between professionals. The other thing I wanted to mention about this issue is the reason why it is important that so many people are arguing these days as to whether it is a good idea or not to solve these situations by given a special power. To the Curia. Let me say that the uniformity system entrusted in Hungary's Curia has been so successful that the Court of Justice of the European Union has adopted it from us. It's a Hungaricum. So for a year and a half now, since its introduction, President Lennart has consistently stated that the Court of Justice of the European Union plays the same role within the European Union as a Supreme Court does in a member state, and this task is to ensure uniform application of law. Of course, in that situation, the uniform application of European law. So interestingly, we happened to invent something new. Why have I mentioned this? Because we are now running into a very, very strange situation. There are cases where it is very important to make a quick and final decision, while our mind task, and this is the, how to say, the magnetic field at our court, that in one case we have to solve the questions very simply and to give a final judgment. From the other side, from the other magnet field, we have to ensure the uniform application of law and not to solve practical questions. Focus on the particular case, focus on the general application of law. In some cases, it's important for the authorities to have a quick decision at the courts, which is ensured by the legislator who sets a final deadline. We face in these situations two requirements that couldn't be fulfilled simultaneously. This is why I try to explain. The Curia should, of course, ensure uniform interpretation and application of law, but electoral adjudication cannot achieve this in cases with short deadlines, 3 days in general. Why? Because it is not possible to conduct uniformity proceedings and long arguments in 3 days. Why? Because uniformity proceedings are inherently lengthy. Just imagine that there are 21 judges. It is not possible to make a phone call in the evening and call in the next morning all the 21 judges to sit in the same hall and to familiarize themselves with a case that would pose difficulties even for 5 judges, because the 5 judges deciding the single case were not able to decide to fulfill the uniform application. This is why they asked the great chamber, the 21 members chamber. It would also pose difficulties for the smaller panel. How long debates would come if 21 of them try to argue and to decide? They should not deal only with the fact that the National Electoral Committee in Hungary made the decision that the petitioner is challenging. Instead, they should address what one panel of judges and the second panel or the third panel stated in a similar case, and whether or not they said exactly the same thing, because it means uniform application. You can see that this cannot be done in 3 days. Consequently, those panels of judges which proceed in these short-term cases have a very, very strong, very, very great responsibility in trying informally to ensure the uniform, I can say voluntarily, to ensure the uniform interpretation and application of law without formal procedural assistance. It is slightly similar to those situations where you waive your rights under some kind of contract. So if I allow someone to build something on my land, I will give up my right to build something other tomorrow. This is necessary, and we have encountered this in specific situations. In fact, it has recently come up in a referendum case and prompted uniformity proceedings. It must give up my conviction that I know better than those who came before me, because this cannot be resolved through formal procedural means. So what does it mean, this informal, voluntary, ensuring uniformity? That I give up my right. I give up my right to write down what I think just because I know better what is the proper answer. And I have to do voluntarily, without formal procedural assistance of the uniformity, the Grand Chamber, and to follow the judges, to follow the panels who decided a similar case in advance. This happens if we have this contradiction. Single case to be solved in 3 days, and the main task of the Curia to ensure uniform application of law. How can this complex legal situation be summarized? Using the example of election cases, I have presented a fundamental contradiction. The same court is obliged to make decision in a large number of similar single cases within 3 days, which uh, court, while the court has the task to ensure that these decisions in all cases will be uniform. The two goals cannot be achieved, as I mentioned, in the same times, but there are many similar contradictions. We expect judges to be politically neutral. I thought about this in some minutes ago. So we expect judges to be politically neutral, while we regularly dispute their political neutrality. We expect judges to be among the best lawyers, while we limit the competition for applications through very, very formal ways. This is how we arrive at the fundamental contradiction. We expect judges to adhere to the provisions of the law, what we do not believe, why we do not believe that provisions of law are unambiguous. And I think this is the end of my presentation. We want judges to find the proper, practically as a parties, the only one meaning of legal provisions, but we don't think that the whole world around us is unambiguous, has a proper meaning. We don't think that justice, not in a legal way, but in the everyday way, can be achieved. In conclusion, I must ask final questions to which I do not know the answer. How can a justice system function if we do not believe in truth? And we do not believe in truth now. This is the era of deconstruction. If we do not consider reality to be determinative, and therefore we do not accept the definition of St. Thomas Aquinas, veritas est adequatio intellectus acrei, truth is correspondence of our opinion with reality. I don't know the question how to solve this, but it's a very, very important question. We wait the truth from the mouths of judges, but we don't believe that truth exists. So I don't know the answer, and I will be very happy if you do find during these days the answer to this fundamental question. Thank you very much for your attention.